Welcome to this presentation where we're going to discuss the nature of the employment relationship. But before we begin, I'm going to go over a little bit of information about how to use this lecture and the related materials. Let's first of all go into Canvas to see what's the structure here is. So I'm going to go ahead and hit the button called Course Content. And here we will see our first module. There's lots of useful information in this module, so please spend some time, especially during the first week, getting acquainted with the information on here. But the two items that I want to focus on in this first module are going to be the textbook, and right now I'm calling it Labor and Employment Textbook and Study Guide. Depending upon when you're viewing this revision date might be different, and I might have named it something different. But in any event, it'll be somewhere in this first module. And it will include all of the PowerPoints and as well as additional material that you will be using for this class. So I have it in a one-stop shopping kind of format. But you'll also see that I have that same information in each module. And so you can see this module is called the Nature of the Employment Relationship, so I have the study guide for this module. So this is the first part of this bigger document. Now I'm not going to revise this document constantly. In fact, I probably won't update it until next semester. So the most current version of all of the study guides is going to be the one that you find in the modules. And these are going to be living, breathing documents. So I'll be tweaking them and adjusting them over the course of the semester. These are our textbook for the course. It's already a very long document, and it's going to get a lot longer before it's done. Certainly won't be done by the end of this semester, but we'll be making progress on it. As you know, this course doesn't have a textbook. That's intentional because I want it to be an open source experience, that it grows with the input that I give and also the input that you give. So let's just go ahead and look at the study guide. I've already opened it. And this is what the study guide looks like. Let me turn off the Pilcrow here. And you can see that this information currently is exactly the same information we see in the PowerPoint. Let me show you what I mean. As I go to the PowerPoint, you can see here, this is module 1, you can see it's slide 2, and this is the information on slide 2. And that exact same information is right here. Let me just kind of randomly go to, I'll just randomly go to, I don't know, slide 21. So you'd say it's called Defining the Worker, and it defines employee and independent contractor. If I scroll down here to slide 21, you can see it says Defining the Worker, and we have employee and independent contractor. Again, as the semester changes or advances, these documents may change from time to time. But basically what this is giving you, at least today, are the PowerPoints in an easy-to-use method. Now my suggestion is to print this up or to use your keyboard and annotate this as you go through. You're probably going to need maybe a page or 2 pages, or maybe a page for 2 or 3 slides. One approach would be to attach another page over here and make your notes on here. There's no point in rewriting what's already been given to you, but if you want to, obviously you can. But just keep in mind that this is a starting point for your notes. This is not a complete version of your notes. This gets you some ideas or some memory refresher, so to speak. But it won't tell the complete story. The lecture is there to tell the complete story. So this is a good starting point, a memory tickler, but just know that you'll need to supplement significantly. I would say probably for however much this information is, you'll probably want 2 to 3 times as much in the way of your notes. So we're going to, so you want to pay attention to this textbook up here. And if you want to print up one version of it that's maybe a little bit easier, you certainly can, or you can print it up unit by unit. If you choose to print it up unit by unit, keep in mind that this won't always match up with this because I will be updating each module, not the big book. The next thing I wanted to flag is this lecture I have. It's still in module 1. So I said, let me go to student view. And you'll see in module 1, you scroll down to have a question. The answer is probably one of these presentations immediately below. This one is a mini lecture describing how to use the lectures in this course. So if you haven't watched this yet, go ahead and turn this lecture off and go watch that so you can use your time in the most productive way. I'm going to assume going forward that you have watched this lecture, so I'm not going to repeat myself, at least not too much. So let's go ahead and look at the structure of a module. As you can see, we start with the PowerPoints, and this is what we'll be spending most of our class looking at. And again, the study guide is just a word version of the PowerPoints. Then you'll see some lectures here. As you go through this course, the lectures will be right below the PowerPoints, and you'll want to obviously look at the lectures. As I say, the lectures is really the textbook for this course. You haven't prepared for any test or any discussion board or any quiz until you've watched the lectures. The lectures are going to be more than 3 hours. There's just a lot of material to do here. And of course, in a traditional class, you'd be spending 3 hours in lecture. You'd probably be spending 3 or 4 or 5 hours out of class reviewing the textbook, outlining your textbook, whatever the tools that you use to prepare. Generally, most people spend about 2 to 3 hours for every hour in class. And because this is combined, both your textbook and your lecture, we're going to be spending more than 3 hours. And so please be aware of that going forward. The lectures aren't going to be just 3 hours of your time. And sometimes you're going to want to listen to the lectures more than once. And you definitely are going to want to pause the lecture and say, wait a second, what did you just say? And go back and listen to that section again. Or maybe you're taking notes and I'm talking too fast for you to get everything down. And so go ahead and pause me. On the other hand, maybe it's your second time listening to the lecture. You might want to put me on a faster speed, or maybe you're in the car driving around or in line at the grocery store, and you may want to put me at a faster speed. So you have some flexibility. That's kind of one of the nice things about an online course, is you can decide when and how and by what method you're going to listen to the course. You'll also see that there are additional tools. And this one, we only have one additional video. Sometimes there's documents here. In most modules, there will be a study guide. These are an opportunity for you to practice from the test bank questions. It's not for grade, it's completely optional. You can do it as many times as you want, or you don't have to do it at all. In most cases, most of the questions that you'll see on the quizzes and on the tests will be from these study guides. So if you're focusing on getting an A, then one strategy is to spend a lot of time on these study activities, because you will see that many of these questions are going to be available to you on the quiz. So if you get to a question that you don't know the answer to, my suggestion would be to go to your study guide and find where I talk about that in the study guide. You'll find the answer and then you'll be able to complete the question. If you can't find the answer in the study guide, of course, you're welcome to come to my office hours. I would be delighted to talk about the issue in more detail. And you'll see below this section, the video section, you'll see the assignment section. And there'll be a discussion board in most modules. There will be an assignment in most, well, maybe about half of the modules. And there will be a quiz. And again, if you want to prep for the quiz, the lecture is the most important prep. And maybe another thing you want to consider is doing the study activity. The quiz is timed, so use your resources well and be sure you're ready to take it before you go ahead and take it. So let's get started on the substance of the course. By the way, some modules have more than one PowerPoint. The reason that some have more than one PowerPoint is simply because of the size. I try to keep my PowerPoints under 100 slides. And so if it was over 100 slides, I probably broke it down into 2 or 3 PowerPoints. So let's get started. Let me go back to the beginning. So here we begin with the course. We're going to talk about the nature of the employment relationship. This first slide, when we cover, I think, all of my modules, there's going to be kind of like a table of contents, which shows you the material that we're going to cover. So this is a major topic, course introduction. The next major topic is the worker as an employee or other. And then there are subtopics within this larger topic. We can see that there are 4. And then we go to our third major topic, the business as an employer or principal. And then our 4th major topic, the employment relationship ends, non-compete, and similar agreements. I think in all cases, my module descriptions all fit on one page. And as we advance, you'll see that I check these items off. So you'll always kind of be able to see where you are. Let me just show you what I mean by that. Advance. So you can see when we get to slide 14, we've completed the course introduction, and now we're going to go into the worker as an employee or other. And again, we see employee or independent contractor. And then we'll talk about that, and eventually this one will get checked off and we'll go to the next one. So it helps you know where you are on the topics as we go forward. You'll also see that, let me just flip over here for a second. You'll also see that in this guide. We'll see our module topics here. And then if we go down here to slide 14, you'll see I have checked it off here. So, in some senses, you might even say, I don't need to see this again. It's not really necessary that you pay attention to this. It just helps you know where you are in the navigation. There's something called the memory palace. I actually have a little bit about the memory palace in our first module. And there it is. And this is a way of organizing your brain. The science is pretty clear that this is a really good way of retaining new information. If you have a place, metaphoric place, in your brain to store it and you have it organized like a file cabinet, or in this case, like a palace, it can make retrieving that information, understanding that information, making connections to various parts of that information a lot easier for you. It's a way to save yourself a lot of study time. And that's really what I'm doing when I give you this roadmap. I'm saying, hey, these are the big concepts. Under this topic, I'm going to give you additional facts. And under this topic, I'm going to give you additional facts. And so I'm giving you the scaffolding to help you figure out where things fit together. And that helps you not only retain the information, but understand the information, because you can see how things are connected to each other. So that's the idea. So yes, in some sense, these organizational slides are a waste of space because they're not giving you new information. But in another sense, they're some of the most important parts of this because they help you see the connections. Hopefully that makes sense. Let's go forward and start the content. Okay, so why do we care about employment law? You probably already have some pretty good ideas since you signed up for the class. But one of the big reasons is that most of us, probably all of us, have been an employee at some point. And it's very useful to know what our rights are as employees. After all, if we're being mistreated or there are rules that are not being followed with respect to our employment, we ought to know that. Perhaps so we can bring it to the attention of our employer, perhaps so we can decide we want to find another employer, perhaps so we can file a lawsuit against our employer. Knowledge is power, and it's important as the employee to have that kind of information. And what you'll discover in this course sometimes will surprise you. You probably, as an employee, have rights you didn't even know you had. And, this is equally important, you probably don't have some rights that you thought you had. Employment law is not very intuitive. Most of our instincts about what the law, or not saying most, but many of our instincts about what ought to be legal or what probably is legal or illegal are not always correct in this area of law especially. So that's one reason we want to know about employment law. But another reason is that you will likely in your life be in the role of managing others. It will be your responsibility, or it has been your responsibility, to comply with these laws that you perhaps knew nothing about. Well, if you're going to manage others, you do need to know that. And that can extend to formal relations where people actually report to you, to more informal relationships where you might be the trainer or the co-worker who has a little bit more seniority who is expected to get another employee up to speed. So managing others is another reason that you need to be familiar with employment law. You may have an idea in your mind to eventually start a business. Wonderful goal to be an entrepreneur. In that situation, you will very likely be involved in supervising others. They may be employees, they may be independent contractors, and we'll talk about that difference in a little bit. And knowing the difference between the two, how your responsibilities vary between the two, is an important part of being an entrepreneur in many cases. In addition, you may want to work in human resources. As you can imagine, employment law is a very regulated area of specialty. And so HR professionals need to have a deep understanding of the law. And so if you are thinking, maybe a paralegal is not for me, maybe I want to be in HR, this can be a good transition for you. When I was working in a corporation, I had a paralegal with whom I worked with, and she decided to make the transition to become an HR manager. She felt it was a better fit for her skills and talents. And so she made that transition and was successful at it. It's not unusual for paralegals who practice employment law to move over into the HR field. And sometimes the reverse happens as well. HR managers choose to become HR paralegals. Another reason to be interested is that the subject is just so interesting. Employees and bosses do the craziest things at work. I will be telling you some of those stories. You probably have some of your own, but it's just a fact that people do insane things at work, and they're probably not fun experiences to live through, but they make great stories. The human experience, the human element to HR is one of the things that makes it so interesting. And then, of course, you may choose to become an HR paralegal or have some kind of general practice that has some HR components. This is kind of the bucket that I'm assuming you're here for. And so the assignments that we have in this class and the comments that I make are going to be focused on giving you these skills. If you happen to be in one of these other categories as well, then the information is still going to be useful, even if maybe the particulars that I talk about may not be as much of a good fit. But the reasons to be interested in employment law are not limited to the subject matter, because one of the wonderful things about employment law is that it involves so many different skills. It's never boring. The people make it interesting, and also the stuff you do make it interesting. So let me just kind of touch base on this. Unlike many of the areas of law, this is a very statutory area of law. We do have some common law, but not a ton. I'd say probably no more than 20% is really common law. Now, we do spend a lot of time reading cases that are interpretation of statutes. So cases are still really important to our practice. But the actual common law, in other words, judge-made law that doesn't come from statutes, isn't as important to this practice area as, say, to torts or to contracts. So we'll be looking at statutes. And a neat thing about many of the statutes we'll be dealing with is that they're pretty straightforward. They're not difficult to read, so it's a good start to statutory reading. As we get farther into the course, some of our statutes will get a little bit more challenging. So we'll have kind of gotten more skills along the way, and we'll be more ready for that at that time. We'll also deal with regulations. We'll talk about regulations in a little bit more detail in a few minutes. But these are really important to this area because this is an area that is highly regulated. And so not surprisingly, we have a lot of regulations to contend with. As I said before, case law is really important to this area. Most of the time, we're going to be looking at cases over either statutes or regulations. Those statutes and regulations are what the cases are interpreting. And then we'll learn about administrative law. We don't spend a lot of time in this program, in the paralegal program, talking about administrative law. There are certain practice areas like employment law that involves a lot of administrative agencies, and it's called regulatory agencies. And it's certainly by no means unique to employment law. But there aren't a lot of courses in our program where we focus on that. So if you have an interest in a practice area with a robust regulation, this is a good course to kind of get you exposed to those ideas, even if employment law isn't your passion at the end of the day. You've probably seen this in other courses, but let me just repeat this to you. This is almost a vocabulary course more than anything else. Think about this course the same way you would think about a course you might be taking in Serbo-Croatian or French. The vocabulary is key. If you're listening to the lecture and you don't know the words I'm using, you don't understand the meaning, you're going to be lost. It won't be a meaningful experience for you. And so early on, please make a commitment to yourself that you will spend the time to develop the vocabulary. Now, this course really does build, and I'm not going to redefine the terms every single time. If you encounter a word that I'm not explaining because I've already explained it in a previous lecture, but you don't happen to remember what it means, just pause me and go ahead and Google it or look it up or do a word search in your city guide to find exactly what the definition for that term is. I will put the term in red bold so you'll be able to quickly find in your study guide the terms that you ought to work on. And I encourage you to use a tool like Quizlet or something else to kind of get those terms pretty easily processed. Quizlet is a tremendous resource. It has a lot of tools. The one I especially encourage you to think about using is the Learn tool. It is set up to really, again, use the neuroscience about how our brains move things from short-term memory to long-term memory. And so by using that science, you're going to likely find that you don't have to spend as much time learning vocabulary using that tool than you might have to if you were using some other tool. You'll see in this program that there are some terms that are everyday English terms, or that are terms that you've seen in other paralegal courses, but we may put a little bit different spin on them. So be aware that just because I'm using a word that maybe I might use in everyday conversation doesn't necessarily mean that it has the same meaning. So be sure to focus on definitions. Here are some abbreviations that I'm going to be using throughout this course. I will get writer's cramp really, really quick, and you will too if you don't develop a shorthand system. So this is the tried and true one, the one that people in this practice area use all the time. Instead of writing out employee every time, we just do EE. Instead of writing employer, we do ER. Instead of writing contract, we do a K. Instead of writing plaintiff, we do a pi sign. If you want to do a P, that's fine, but I'm just telling you that's what practitioners use the pi sign. We use a delta sign for the defendant, and you can use a D, but delta is probably a little bit quicker, maybe not. For exempt, we use EX. We'll talk more about what exempt means later on, but these are some good shorthands. You'll see when I'm writing up and making notes, I use these all the time. I'll try to remind you what they mean, but I may well forget, so you might want to keep this cheat sheet handy for your own edification as you watch lectures and write your own notes. So we're going to talk about sources of law, and our first source of law is going to be constitutions. So you may recall when you were taking intro, we talked about primary sources of law. This is the same thing. So we're talking about the same concept. And, you know, constitutions, we have both our federal constitution, the U.S. Constitution, and we have the Texas state constitution. You know, they're the organizing documents to how our democracy works. They're really important, except not important to this practice area. There's very few issues really that deal with constitutional issues that deal in employment law. Now, having said that, I will tell you there are a couple of exceptions to that. One exception is that if you are a public employer or you are a public employee, there are constitutional rights that attach to that employee when he or she is working for that public employer. So there are constitutional ramifications in that situation. But with private employers, there's almost no constitutional implications. There is one other exception I want to share, and that is some state constitutions provide protection to even sometimes private employees. A famous example of that is California. California's state constitution gives private employees certain protections. We'll talk about those in a little bit of detail when we talk about privacy in a later module. They don't apply in Texas, obviously, and so it's not directly relevant here. But if you happen to, at some point in your career, practice in California, or you work for an employer that has offices in California, you'll need to be aware of the special issues that arise in that state, and there can be other states where this is an issue as well. So constitutions are important generally, but not so important in this particular course. And by the way, going back to that first point about public employment, there is so much to cover in this course, and you'll see that there is a lot as you go forward. We just don't have enough time to spend much time talking about public employment. So I'm focusing on this course in the private employment area. I will touch a little bit on public employment in our privacy section, but for the most part, I'm not pretending to do a deep dive into that or even a shallow dive into that topic. So if you end up working for a public employer, you become a public employee, just know that what you've learned in this course is not a very thorough exploration of those issues. So let's talk about our second primary source of law, and that is going to be statutes. If it's, of course, at a state or federal level, we call it a statute. If it's at a local level, we're going to call it an ordinance. And of course, these comes from the legislative branch of our government. So we're talking about the Congress, and we're talking about the Texas state legislature. We could be talking about the city council in a particular city like Plano or Frisco, or we could be talking about the county commissioners in Collin County. Those would be examples of ordinances. But whichever branch it is a legislative branch. Now, obviously, in the case of the state or federal, the legislative branch approves or writes or votes to ratify a particular statute, but the president or the governor, if we're talking about the state, has to also sign it, or at a minimum, if the president or governor vetoes it, the legislative branch has to go back and overcome that veto, which is a fairly rare situation. So these are rules or written commands which promote or prohibit certain conduct. These are really, really important. This is the single most important part of the tools that we have in our practice area. We're not going to spend as much time looking at statutes as we will look at cases, but the cases will primarily be interpreting the statute. So our source document will be the statute. So this is a really important ingredient. Then we have regulations. And these are the documents that agencies within either our state or federal government develop to give more detail and more granularity to the statutes. If we think about the statute as a tree, we might have some branches off the tree. That would be the statutes. But the leaves and the little twigs, all of the details, all of the minutia is going to be in the regulations. And so we'll spend a fair amount of time talking about regulations. Now, of course, regulations can't contradict the statute. They have to comply with the statute, but the statutes typically are not designed to get in the weeds, to talk about the details. Let me give you an example. I'm going to give you an example outside the area of employment law, then one example within the area of employment law. Imagine that the EPA, or the Environmental Protection Act, is passed by Congress. Well, it has been passed by Congress. And it creates, it's called an enabling statute. It creates the Environmental Protection Agency. And that agency then goes out and hires a lot of smart scientists who develop the scientific research to establish what the correct levels of various chemicals could be, issuing from smokestacks to waterways to other types of potential polluting opportunities. And it says how many parts per billion we can have of this chemical or that chemical. It would be ridiculous for all those details to be in a statute, because our congressmen and women don't know very much about science. I mean, I'm sure there are some scientists there, but for the most part, they lack the scientific knowledge, and they certainly lack the time to do the scientific research to know what safe levels would be. And also, these standards are going to change over time as we develop more scientific knowledge. And so it's pretty hard to pass a statute. And so it'd be pretty hard to constantly be revising statutes. It makes a lot more sense to have a fairly generic, a fairly, I won't say vague, but a statute that doesn't fill in all the dots, and then give that responsibility to dive into the weeds to that agency that can hire the specialists. So that would be an example of an agency. Let me give you an example in the area of employment law. We have a statute that was passed decades ago now, but it's called the Family and Medical Leave Act. And one of the things that Congress did when this law was passed is it said that anytime an employee, or anytime most employees have a serious health condition, they are entitled to up to 12 weeks of unpaid leave. And this became law. It was signed into law, and it became the law back in the 1990s. But the statute didn't define what a serious health condition was. Now, there are two ways of looking at why they didn't define it. One way is to say, well, Congress passed the buck. They didn't want to make the hard calls. They didn't want to decide exactly what that term should mean, because they didn't want to antagonize people who thought it should have a broad definition. They didn't want to antagonize people who thought it should have a narrow definition. That's probably the correct answer. That's probably the main reason. But the second reason, which also perhaps has some validity, is that they recognized that they weren't HR professionals. They were legislators. And so they thought, well, why don't we let the experts, why don't we let the people in the Wage and Hour Administration, people who've spent their lives in the HR field, come up with a definition for this that makes sense given the realities of the workplace. And so that's exactly what happened. And the Wage and Hour Administration came up with a very long, very exhaustive definition of what a serious health condition is. You may agree with it when you see it, you may not agree with it when you see it. But the one thing that you will leave, I think, agreeing is that it's clear what's covered and what's not covered. Without that definition from the Wage and Hour Administration, who would know what a serious health condition is? I wouldn't. You wouldn't either. Even the legislative branch wouldn't know, because they said that's too detailed for us. We're going to let the experts worry about that. So that's why regulations are an important part of what we're going to be doing in this course as well. And then this isn't its own area law, but this is a list of kind of the agencies that come up with these regulations. We have the EEOC. This is probably the most important one that you'll be working with if you become an HR paralegal. The EEOC is an agency that administers most of the discrimination laws, employment discrimination laws. We have some interaction with the IRS, the Internal Revenue Service. We'll talk about that a little bit, but probably the second most important agency is the Department of Labor. I just said the Wage and Hour Administration, which is part of the Department of Labor. You might think that the EOC is probably a part of the Department of Labor, but it's not. It's an independent agency. The Department of Labor wears many hats, but it does not wear the employment discrimination hat. And then we have the NLRB. This is probably the third big agency that we'll deal with. Mainly we'll deal with this in the labor chapter. And this is the agency that handles union campaigns and issues that relate to unionization issues. Not a big topic in Texas, but if you move to other states, it can have a more significant relevance. So these agencies are the agencies that develop the regulations we're talking about here. But they have roles beyond creating regulations. They are also involved in adjudicating cases. So let's imagine that you work for the ABC company, and one of the employees of ABC files a charge of discrimination. Well, what that employee is likely to do is go to the EEOC to file that charge, and the EEOC will investigate the charge. And so you, as the HR professional, will respond to that charge and write a letter to the EEOC, which we call a position statement, that explains what the position of the employer is with respect to that charge. So agencies aren't just doing kind of quasi-legislation, they're also doing investigation, kind of like an executive branch function. And some of those agencies even do adjudication type roles, kind of like judges. So they also have kind of a judiciary function. So it's kind of interesting. Administrative agencies kind of have all three types of branches of government all within themselves. So let's go to our next primary source of law. We talked about constitutions, statutes, and regulations. Our fourth one is going to be judicial decisions. This is going to feel like the main thing we do in this course. I talk more about case names than any of these other things. I want to refresh you, though, that this is the main thing. The cases are just interpreting the statutes, but it's going to feel like this is the big thing. So what are judicial decisions? Well, they're things that judges have written, they're documents that interpret what has happened in the executive branch, which of course is the administrative agencies, and the legislative branch. Sometimes judicial decisions will come down that are part of the common law, so they're not interpreting these. But as I said, the common law isn't as important as statutes to this particular practice area. So now we have our first term, stare decisis. This is a Latin expression. Stare means to stand. And you can see here, if you look at the first three letters, they're the first three letters of the word stand. The RE ending is an infinitive ending in Latin. If you know some French or Spanish, you're probably not surprised by that, because those are infinitive endings in those languages as well. So it's not surprising when you look at it from that perspective. You can see this is an infinitive ending, so we know if we're going to translate it to English, we're going to start with to, and we can see the beginning of the word stand, so to stand. Then we have the word decisis, which, as you can see, looks very much like the word decision. So it's not surprising this means to stand by a decision. So what stare decisis means is that a judge is going to follow decisions made by higher courts than his or her court, or by courts at an equal level to his or her court within his or her jurisdiction. So let's imagine that I am a federal judge in the Northern District of Texas. Well, that means that I'm likely to follow the decision of other judges in my court in the Northern District of Texas. And I'm definitely going to follow decisions by the Fifth Court of Appeals, which is my higher court, because the Fifth Court of Appeals covers Texas, Louisiana, Mississippi. And I'm definitely going to follow the decisions of the U.S. Supreme Court, which is the court higher than the Fifth Circuit. I, however, don't have to follow decisions by judges in the Eastern District of Texas or the Southern District of Texas or the Western District of Texas. I don't have to follow decisions by judges in California or Montana or Massachusetts. I also don't have to follow state court decisions. So it's important to understand whether I'm in the state system or the federal system to know which decisions are binding upon that particular court. And also to know where the court that I'm in, how it fits into that hierarchy. To know what decisions are important. If I'm the litigant now, not the judge, what decisions are important for me to present to the judge in the hopes that I will persuade him or her. Our fifth tool, fifth primary source of law, are executive orders. These are decisions by the chief executive officer in that government. It could be the president of the United States or it could be a governor. And these decisions, these are orders, are to the employees in that either federal government or the state government, telling them how to conduct themselves. The governor and the president can't direct you and me, private citizens, to do things. That's the role of the legislative branch. But the president can tell people in the IRS how to handle certain matters, or people in the military how to handle certain matters, or people in the immigration service, or things like that. So, and of course, those agencies then can affect everyday individuals, at least to some extent. So there is some capacity for the president and the governor to issue executive orders that indirectly impact you and me as private citizens. This isn't an area of significant amount of regulation that we're going to deal with. Probably the greatest area that we're going to see executive orders playing a role is going to be in our extra credit chapter, which is our affirmative action chapter. So we'll be seeing some information about that as we move along in the course. The sixth item I have on this list is not a primary source of law. So I'm not going to call it 6 because that would be confusing. I'm just going to put a little asterisk here. And that is contract. Contract is an area of private law. It's almost like a law between two or more private entities. And of course, in this context, we're talking about a contract between an employer and an employee. And for the most part, those contracts can be whatever the parties want, assuming they are not, in some sense, unlawful. You know, I can't hire somebody to make counterfeit currency for me or to kidnap somebody for me. Those kinds of contracts would be unlawful. But assuming I'm hiring someone to do something lawful, and I'm paying them on a lawful basis, for example, I'm paying them more than the minimum wage, the terms of that agreement are pretty much going to control. So there can be a give and take at negotiation. You may have already taken contract law. If you have, then you'll be familiar with some of these concepts that I'm talking about here. But for the most part, people can enter into a contract to do what they want to, assuming it's not unlawful. There are some aspects of contract law, though, that are affected by the fact that it is an employment relationship. So if you have taken contract law, you are a leg up on your colleagues in the class when we talk about employment contracts. But there are some important differences between employment contracts and other types of contracts. So when we think about employment contracts, my guess is many of us immediately thought, oh, we're talking about written contracts, maybe that the CEO of a company is entering into with his or her company. And certainly those do happen. We would call those written employment contracts right here, right? But they're not very common in the United States. In some other countries, they are more common. But it's relatively rare to find written employment contracts unless you're a sports star or maybe a famous actor or a very senior executive in an organization. What companies do in terms of when they have written employment contracts really varies significantly. When I was at JCPenney, at times during my employment, there was not a single employee who had a written employment contract. That was a relatively short period of time. But there was a long period of time where there was just a handful, less than 5 employees had written contracts at JCPenney. There were other times where there were over 100 employees who had written contracts. And so, and during those times, JCPenney had about the same number of employees. So there can be a lot of differences in terms of corporate philosophy about whether written employment contracts are good things or bad things. And certainly, even if an employer decides they're good things, what goes into the contract, what type of terms and conditions apply are going to vary. And so written employment contracts are not tremendously common in our culture, but if you work in an employment law practice, you probably will have some exposure to this area. But a much more common document that we see is an employment offer. Usually this is going to be in writing, and oftentimes the employee responds to the employment offer with a written acceptance. These can create employment contracts. They don't always create employment contracts. We'll talk more about that as we go forward. But they do function in certain respects, they have the potential to become employment contracts. Much of this, by the way, varies from state to state in terms of how the law works. So we're not going to do too deep a dive at this point. We also have union contracts. Again, Texas is not, for the most part, a highly unionized state. So this isn't going to be as much of an issue here as we might see in other jurisdictions. But when you have a union contract, everyone who works in that particular bargaining unit is bound by the terms of that contract and enjoys the benefits of those terms of the contract, even if he or she didn't particularly like those terms. So the contract is an important document, both the negotiation, the process, as well as the enforcement of those terms are things that HR professionals and HR paralegals are definitely involved with. And we also have things called implied contracts. These are things that are not written, they're not even oral, but it's things that kind of everybody understood was part of the deal. And those are things that we will talk about. For the most part, that's not a very fertile ground for a claim in Texas. Other states, especially California, it can be a very fertile ground for advancing that theory. The one thing that I don't have on this list is an employment at will. We'll talk more about that contract as we go forward. We'll spend a great deal of time talking about employment at will. Let me just write it right here so you can see what I'm talking about, at will employment. This is a really important term, much more important to our practice area than any of these other categories, especially in Texas. And we'll spend a significant amount of time on this. Let me go to the next slide. So sometimes what happens in this area is that we have competing state and federal statutes. You may recall I talked about that we have state, federal, and local statutes that can impact employment law. Well, what happens when the statutes don't agree? You have a federal statute that says X, you have a state statute that says Y. How do we know which rule controls under those circumstances? Well, generally the rule is that whichever law provides the maximum benefit or the maximum protection to the employee is the one that controls 90% of the time. I would love to say it was 100% of the time because that would make it easy for the purposes of this course. But unfortunately, it's not 100% of the time, it's 90% of the time. Most of the time, the federal statute provides what we call a floor. This is the minimum protection that all employees are entitled to. But the federal statute permits the states to give additional protections above that. So you might have, we'll call this the federal level. You might have state A provide just that level. It doesn't give any more protection than the federal law provides. State B gives a little bit more protection. State C gives a little bit more, and State B maybe gives the most. So in this situation, if I'm in State D, honestly, I don't really care about federal law. I care about my state law because that gives me the best protection or the best benefits. If I'm in State C, I don't get the benefit of State D protection, but I do get more benefits than I would if I were in State A or State B. Well, let's imagine we had State E, whose protections were less than federal law. Well, that doesn't apply to anybody because the federal law provides a guaranteed minimum level of protection. So that's how it works 95% of the time, 95% of the time. We say that law E down here is preempted by federal law. Federal law controls, and so E doesn't apply. But we say that federal law does not preempt states A, B, C, and D because they provide the same or more generous benefit. Those laws remain in effect because the federal law explicitly says in those cases, we are providing the ceiling benefit. We're not providing the most, we're just providing the minimum level. Now there is one statute that doesn't work this way. There's always got to be one statute, right? And that's the ERISA statute. We'll talk more about ERISA later on. ERISA is the statute that relates to employee benefits. And in that situation, federal law provides what's called a floor and a ceiling. Federal law says, listen, we're the only game in town. We're going to tell you how to do this stuff. And states just need to stay out of this area. They can't provide more benefits. They can't provide fewer benefits to employees. They need to just stay out of this area because we're the only governmental agency that's going to be able to dictate. So ERISA is a little bit different, and we will have a section almost in the course about ERISA. I always want to flag this though because this is that one exception. This is the 5 or 10% of the time that we don't have this ceiling approach. And we'll talk when we get to that section why it's different and how that makes a difference. So what do employment disputes look like? And I phrase this as how we see the style of a case. When I use the term style in a case, I'm talking about the name of the case. And most styles are the plaintiff versus the defendant. At least that's the way it is in the trial court. So let's imagine that you again are employed by ABC Corporation and Bob Smith, who's an employee, sues ABC Corporation. So we would have Smith versus ABC Company, or ABC Corporation, I guess. So that's the name or the style of our dispute. And that's how it looks at the trial court level. But let's imagine that Bob Smith loses at the trial court level. The jury didn't buy his story. And so ABC Corporation prevails, but Bob wants to file an appeal. So he goes, we'll say we're in federal court. So he goes from the Northern District of Texas. We'll say he was in Eastern District of Texas. He went from the Eastern District of Texas to the Fifth Circuit. Well, he used to be the plaintiff at the trial court level, but now he's the appellant. So his name still goes first. And ABC Corporation is no longer the defendant, because they're not at the trial court level anymore. It's the appellee, so its name goes second. And so the style remains Smith versus ABC Corporation. But let's switch the facts. Let's say instead of Bob losing at the trial court level, he wins. And so he's happy with what happened at the trial court level. It's ABC Corporation that's bummed. Well, how did that happen to us? We're very mad. We think an injustice was done. So ABC Corporation is the one who files the appeal. It was the defendant at the trial court level, but now it's the appellant, and Bob Smith is the appellee. Well, in most courts, they flip the order. So ABC Corporation is now going to go first. It was the defendant. It's now the person's appealing. And so at the appellate court level, its name will be first. And the appellee, in this case Bob, the former plaintiff, his name goes second. Now here, I'm just looking at the trial court level. So this is trial court. So the plaintiff is first and the defendant is second. This is the usual one. I mean, this is like 97% of the time. This is the style that we have in litigation. The employee is mad at the employer. Usually it's because the employer's fired the employee, but it doesn't have to be that way. There's some other scenarios that can arise, but that's the usual. Fired employee sues employer, usually because of some discrimination claim. Very small percentage of cases, the employer might sue the employee. Maybe the employer fired the employee for theft. And now the employer is suing the employee. Maybe the employee embezzled $1 million. In fact, recently there's a story in the news how McDonald's is suing its former CEO because he, in McDonald's opinion, he had misrepresented some information and had gotten a severance arrangement based upon that misrepresentation. And so McDonald's is suing that individual. So you can have an employer sometimes suing an employee. Probably a more common way this comes up is when the employee leaves the employment of the employer and goes to work for another company. And perhaps this new employment arrangement, in the opinion of the former employer, violates a non-compete agreement. And so the employer sues the former employee and maybe the employee's new employer, which of course would be the private party. And so that can be another way that this develops. You can have one employee suing another employee. Sally made or inappropriately touched Bob at work repeatedly. Bob decides he's going to sue Sally for battery. So it would be Bob Smith versus Sally Green, Smith v. Green. Bob might also want to sue the employer, their ABC Corporation's employer, saying, well, ABC Corporation knew about the harassment and didn't address it. So that can be another way that the employment discrimination case develops. You can have a third party sue the employee. Again, this could be a situation where, I mean, this is another way of looking at this issue, honestly. If you happen to be representing the employee's new employer, then this is what it feels like perhaps to you. You can have other situations. Maybe the employee punched a customer in the nose in the store. Well, that customer might be suing the employee as well as the employer. Perhaps the third party, it could be that the new employer of the former employee is suing the old employer for some type of misrepresentation. Maybe the former employer gave a reference to the new employer that ended up being inaccurate, and that new employee came to work for the third party employer and stole a lot of stuff, and so now they want to sue the employee's original employer for misrepresentation. Another common way that these cases develop is that the government, oftentimes the EOC, will sue on behalf of the employee, the employer. So going back to the example I have with Bob Smith, in this scenario, Bob sues his former employer on his own behalf. But probably Bob had to file a charge with the EOC before he was able to file his lawsuit against his former employer. And the EOC in those situations has the option, rarely takes advantage of the option, but it does have the option of saying, Bob, we're going to represent you. Instead of you representing yourself, we're going to take over this case and we're going to sue on your behalf. And we're going to sue your former employer. So that would be a situation. The EOC can do that. There are other governmental agencies that can do that, including the Department of Labor and the Department of Justice. Sometimes the government may sue an employee. For example, an employee who might have been involved in paying bribes in perhaps a third world country. In that situation, the government could sue or could prosecute the employee, but also whomever the employee's company is. So there's lots of scenarios, but certainly the most common would be this one by far. This one's a fairly common one, and probably those are the two main ones that merit most of our attention. Let's talk a little bit about the concept of regulation. So this is the idea. The idea is that employees need a little bit of help. That's why we regulate employment law. That if we didn't have government regulation, that the workplace would not be very fair. That's the idea. Now, some people agree with that idea, some people disagree with that idea. Probably most of us agree with it partially and disagree with it partially. And so this really, for most of us, probably comes down to an issue of, well, I think this regulation makes sense. I think that regulation doesn't make sense. Here are some examples of areas that get regulation. For example, we have a minimum wage. We have overtime provisions guaranteeing people time and a half after they've worked a certain number of hours in the week, or in some states, even in the day. We have certain safety rules, and related to that, health rules. We also have collective bargaining rules for those groups of employees who've chosen to unionize. And then we have certain prohibitions in terms of employment discrimination. We have certain categories of characteristics that employers are prohibited from considering when they make employment decisions. And then we have some exceptions to the at-will employment doctrine. We haven't talked about that yet, so I'm not going to get ahead of myself and talk too much about that. So, let's talk a little bit about the idea of regulation. So I guess there's kind of two arguments for why regulation may not be necessary. One is the idea that, we as employees or as individuals have the right to pick who we want to work for. And if, let's say, I'm a 16-year-old who wants to get her first job, I can go to work for McDonald's, or I can go to work for Burger King, or I can go to work for Sonic or Subway or whatever business is looking to hire. And if McDonald's is offering me $8 an hour, but Burger King is offering me $8.50 an hour, then I'll very likely pick Burger King. Or maybe I'll go to McDonald's and say, hey, I really prefer to work for you, McDonald's, but I need you to match or do better than what Burger King is going to offer me. And so that it's true that the employee has the capacity to leave one employer to go to another, or to seek several positions and choose the one with the best benefits and the best pay and the best working conditions. And similarly, employers can do that too. When I, the 16-year-old, apply to work at McDonald's, McDonald's isn't just interviewing me, they're interviewing other people, maybe 16-year-olds, maybe 26-year-olds. And making a decision about who would be the best to work in their enterprise. And they may choose the 26-year-old over me, or maybe they'll pick somebody, or maybe they'll pick me or someone else. And so they have the ability to, there is a give and take and negotiation that can happen. And so capitalism, the idea goes, will address many of these problems that might exist. But we've seen that capitalism does not seem to perfectly address these issues. We know back in the early days of the Industrial Revolution that there were sweatshops where people were worked many, many hours in unsafe and unhealthful circumstances and were earning very little money. And so it seems pretty clear that capitalism doesn't always work. We had capitalism even during times where there was great racial discrimination and great sexism and other types of discrimination. And so workers who were women or African Americans or Hispanic individuals oftentimes were paid significantly less, even though they had the same or better skills than the other people who were employed. So capitalism doesn't seem to, in every circumstance, be a complete fix to these issues. Another reason that people oppose regulation is that whenever you have regulation, there's a kind of a restriction of freedom. You have to limit how you are going to run your business. And you might say, well, but nobody, I mean, we ought not have people be free to discriminate. And certainly that's true. But as soon as you say, well, you can't do X, then the employer might say, well, I never wanted to do X, but now I have to worry when I do Y that somebody will think I'm doing X. So imagine that again, I have 3 applicants. One person who is a good friend of mine whom I've known for lots of years, but doesn't have a lot of experience in the area, but I know he's going to be incredibly hardworking because I've known him for so many years, and I know how hardworking he is and how smart he is. And I know how committed he is to this position and how committed he is to me and to the success of my business. The other 2 employees are of a different ethnicity than my good friend, and they have significant more experience in this area. I want to pick my friend. I think that will be the better choice for my business. But if one of these other 2 individuals were to file a charge, it looks like discrimination because the person I'm ultimately going to hire on paper has fewer skills than the 2 unsuccessful candidates. Even though race isn't the reason, it appears to be the reason. And you can see how that can feel stifling to the employer in terms of his or her flexibility. And so he might say, we'll say it's a he might say, well, I'm not going to hire my friend because I can't afford to hire an attorney. I can't afford to go through that process if one of these other 2 individuals complains about this. And so now I'm not going to have the best worker. I'm going to have somebody who may be good, but isn't as good as my best case scenario. That type of mentality is one of the reasons why some people say regulation isn't good. But there's lots of reasons why regulation can be good. The reality is that people can be darned irrational. I know this is no big news flash for any of us, right? But people can be irrational. People can make decisions that aren't very logical. Let's go back to the example that I just gave you about my dear friend. Well, if I'm like most people, my friend is probably of my ethnicity. Most of us have friends of our same ethnicity. And so if we gave people a carte blanche to only hire their friends, well, we would find that people who happen to be a member of the racial or ethnic group that has the most assets are able to continue to be the group with a disproportionate amount of assets. And even though maybe I don't intend to discriminate, human nature is human nature, and I'm probably going to have friends who kind of look like me, who kind of have my life experiences. And if I am allowed to hire those people, it may lead to me making irrational decisions, but that's likely to be what happens. Discrimination. Discrimination is sometimes a very conscious thing. We certainly know that there are people out there who have evil minds. But much of discrimination that happens is unconscious. People aren't aware of their prejudices, their prejudgments. They think they don't have them, and they don't maybe consciously have them, but on some level they do have most of us do have some prejudgments that we engage in. And so it's very difficult to filter those out. By prohibiting discrimination, we're giving a vehicle for redress for those individuals who are the victims of those types of discrimination. There's those market imperfections. Companies can have biases, but still be successful. Now, I suppose a company that was completely without bias would be slightly more successful because they would do a better job in their business model. But the reality is that there are market imperfections that cause businesses to still be able to be successful and competitive despite having some imperfections. But probably one of the biggest reasons we think that regulation is a good idea is the idea of a social contract. And when I use this term, I'm not using it in the legal sense of contract, but I mean this in the idea that we as a culture, we as a society, we as a country kind of need to look out for each other's backs. We need to take the view that, you know what, it's not just what's good for me, it's what's good for my neighbor. Even if my neighbor is somewhat different than me, of a different race or different religion or different gender or whatever. And if I protect that person, maybe in the future that person will protect me. We're kind of all in this together. That notion is part of the idea about why regulation can be helpful. And the final one is not by any means the least important either, and that is the idea that in many markets, employers have a disproportionate power. In my example, I was talking about that 16-year-old who had lots of different job offers. And sometimes, in some economies, in some parts of the world, that may be the case. But many times, especially for people who don't have a lot of skills yet, there may just be one employer. And so that employer could offer pretty much any wage, and the employee would have to accept it because there aren't other options. And once that employee comes on board, it may be hard for that employee to find other employment quickly. So if the employer fires that employee, the employee might be in for a hard time before he or she can find another place of employment. So the employer may find it easier to hire and to replace, and the employee will find it easier to find the next position. So the power is not always that equal between the employee and the employer. Let's talk about the concept of freedom to contract. This is very, very central to our legal system. There's hardly anything more central than this idea. And it's so obvious, I think, to people in our culture that to almost say it is like, well, what? What do you mean? Of course we have that. Why are you even wasting our time talking about that? And the idea behind freedom of contract is the idea that for the most part, I can enter into a contract pretty much with anybody I want to. If I want to go to Target and buy a loaf of bread, I can go to Target and buy a loaf of bread. If I'd rather go to Tom Thumb and do that, I can go to Tom Thumb. It's my choice to do that. If I want to work for McDonald's and McDonald's wants to have me work for it, we can do that. If I don't want to work for McDonald's, I don't have to. If McDonald's doesn't want to hire me, it doesn't have to. That's the idea of freedom of contract. That the two entities can't be made to enter into a contract with each other. And also a step farther, that the terms of that agreement is for those parties to figure out. So let's imagine that I want to work for McDonald's, but I don't want to work on Friday night. That's my night to go out with my friends. I'm happy to work on Wednesday and Thursday night. I'm happy to work all day Saturday, but I don't want to work Friday night. When I go to my interview and I'm offered the job, I tell them, hey, I want to work here, but not Friday night. McDonald's can say, that's a deal breaker for us. We need you Friday night, so we don't have a job offer for you. That's fine for McDonald's to say no, and it's fine for me to say I won't work Friday night. It's also fine for McDonald's to say, okay, if you don't want to work Friday night, that's fine with us. We'll see you, on Wednesday night. You'll work then. And so the terms and conditions and hours and wages, all of that is largely left to the parties to figure out. We call this idea freedom of contract, but we have another idea in the area of employment law, and that is the idea of at-will employment. And I talked about it briefly earlier, but now I'm going to do just a little introduction here. And that is, at will means that the employee may choose to work or not choose to work for a given employer. In some sense, I decide every day whether I'm going to work for Collin College today or not. If I decide tomorrow morning that I'm not going to work for Collin College anymore, I can call up, I can send an email, call up, write a letter, however I go about doing it, and tell them I'm done. And guess what? Collin College can't make me work for it another minute. It's going to stop paying me, but it has to pay me up until the second that I submitted that document. So I get to end my employment whenever I want to. Now, it's not a good idea to end your employment like that. I'm not saying it's a wise policy for me to make, but I have the legal right to do all kinds of things that aren't smart. So that's the first side of at-will employment. And I don't think anyone's too surprised that we have the right to leave. I mean, after all, we're not in some kind of indentured servitude to our place of employment. The second part, though, is the part that sometimes surprises people. And that is the employer can choose to hire somebody or not choose to hire somebody, or the employer can choose to dismiss somebody or not dismiss somebody at any time, for any reason, or no reason at all, except that it can't be an unlawful reason. So let's imagine that I go to work for Collin College tomorrow in a meeting, and I happen to be wearing a green blouse. My boss walks in and says, you know what? Everybody is wearing any green item, stand up right now. Well, I stand up, I'm wearing a green blouse. A couple other people stand up too. Okay, you're all fired. I hate green. I don't ever like to see people wearing green. You're out of here, bye. You're done. What? What just happened? I got fired because I was wearing green? I wasn't warned that green was problematic. There's no particular meaning associated with it. It's not St. Patrick's Day. I'm being fired because I wore a green shirt? That's crazy. That's stupid. I completely agree with you. It is crazy. It is stupid. But it would be perfectly lawful to do that. The employer is entitled, if an employee is at will, to dismiss somebody for stupid reasons, for no reason at all, if there isn't an employment contract. Now, an important caveat is that there are some exceptions. There are some unlawful reasons. These, if you think about the universe of reasons why a person might be fired, these would be these little exceptions or these little circles. I mean, there's lots of them. There's lots of these circles. But the vast majority of reasons why someone can be fired are not going to be included in these circles. All of the spaces that aren't in these circles are perfectly lawful reasons. So everything out here, all of these are lawful reasons. Some of these reasons are stupid. Some of these reasons are ridiculous, like wearing a green shirt. But they're lawful. If there isn't a statute or common law principle that makes a reason unlawful, the employer is perfectly fine doing the employment relationship with no notice, for no reason, for a bad reason. All of that is the case. Now we're going to spend the rest of our course, for the most part, talking about these little carved out areas, these little circles here. But sometimes when we talk about these circles, it's easy to start getting this feeling like, oh, well, that's the whole world. That's like almost all the reasons why anyone is ever fired. And I will try to return to this from time to time to kind of refresh us on the fact that No, these little exceptions are like 1% of the reason or 2% of the reason why people are fired. They aren't the main reason people are fired. They're just a very narrow set of reasons we've carved out and said, you can fire for almost any reason except for these handful of reasons. And so the course is about these little exceptions, but most of employment law or most of employment practices is about all of the areas that don't fall into these exceptions. So at this point, we have now completed our first category, course introduction. So in our next section, we'll talk about the worker as an employee or other. At this point, I'm going to go ahead and end the lecture, and I thank you for your attention. Be sure to watch the next lecture for more information about the nature of the employment relationship. Have a wonderful day. Take care.